Before we start this video, do like and subscribe to our channel and not miss on any updates.
Hello everyone. Let's start with the discussion of December 23 RTP of CA Foundation Paper 2 Business Laws. So the first question here is, Sheetal was a classical dancer. She entered into an agreement with Sharad Vidya Mandir for 50 dance performances. As per the contract, she was supposed to perform every weekend and she'll be paid 8,000 per performance. So there was this contract which Sheetal had with this Sharad Vidya Mandir, wherein she had to perform dance performances every weekend and she would be paid 8,000 for each performance. However, what happened was, after a month, she was absent without informing due to her personal reasons. So she did not turn up for the classes, and all of this was due to her personal reasons. Now, what are the questions? Let's have a look at them. Whether the management of Sharad Vidya Mandir has a right to terminate the contract. So here we'll use section 39 of the Indian Contract Act, and as you all know, section 39 says that in a situation wherein a promisee fails to perform their part of the promise, then the promisor also has a right to repudiate the contract. So yes, here in this situation, Sharad Vidya Mandir has got a right to terminate the contract. What is the part 2 of the question? Let's see. If the management of Sharad Vidya Mandir informed Sheetal about its continuance, that is, if they did not terminate the contract and were interested in continuing it, can the management still rescind the contract after a month on the grounds subsequently? Now, section 39 also specifies that if a contract was not terminated earlier and the management had, by their actions or by words spoken, have implied that they are interested in continuing the contract, then later on the same grounds they cannot remove or they cannot rescind that particular contract. So in this particular situation, if the management has continued the contract, they cannot subsequently rescind the contract. So subsequent rescission is not possible. The third part of the question says, can the Sharad Vidya Mandir claim damages that it has suffered because of this breach in any of the above cases? So whether the contract is being terminated or whether it is being continued, in both the situations, damages can be claimed. So yes, in both the situations, both the above situations, damages can be claimed by Sharad Vidya Mandir. Let's move on to the next question. Paridhi, a minor. So this girl is a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, who is owner of MP Laptops, for purchase of a laptop on credit, which amounts to 60,000 rupees, and this agreement was entered into on 1st of August 2022. So this girl, she is a minor but presents herself to be a major, enters into an agreement for purchase of a laptop on credit. The value of the laptop is 60,000 rupees and this agreement was made on 1st of August. She promised to pay back the outstanding amount with an interest of 16% per annum. So she promises to pay back the outstanding amount with an interest of 16%. And she also told him that in case she won't be able to pay the outstanding amount, her father will pay back on her behalf. So what does she say? She says that just in case I am not able to pay back the amount, then my father will pay back the amount. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is a minor and he cannot recover a single penny from her. She'll be a major on 1st of January 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will succeed in recovering the outstanding amount. So let's see if it is possible or not. Now, as you all know that a contract with a minor is void ab initio, which means it is void from the very beginning. There's no validity in a contract which is made by the minor at all. Let's have a look at the questions here. So by filing a case against Paridhi, a minor, for recovery of outstanding amount with interest. So can Mr. Mittal succeed in this type of case? Definitely not. Though Paridhi has represented that she is a major, she is at fault here, but Mr. Mittal cannot recover the outstanding amount by filing a case against Paridhi. Second situation is by filing a case against Mr. Ram, who is the father of Paridhi. So here comes the capacity of a minor to bind their parent or guardian. So in this particular situation as well, Paridhi in this situation will not be able to bind her father with the act which she has done. So Mr. Mittal will again not be successful in recovering the amount from Mr. Ram. And then the next situation is by filing a case for recovery of outstanding amount after she attains majority. Now, as you all know, that the acts which have been done by the minor cannot be ratified once they have attained the majority. So, ratification is not possible at all. So, in this situation, also, Mr. Mittal cannot recover the amount. Let's move ahead. Rohan found a wallet in a restaurant. He inquired all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep the wallet till the owner is found. After a week, Rohan went back to the restaurant to inquire about the wallet. However, the manager refused to return it to Rohan, saying that it did not belong to him. In the light of contract act, can Rohan recover the wallet from the manager? So this is a situation of finder of lost goods. Now, finder of lost goods is basically a person who has found someone's lost property, and it is his responsibility to make sure that the good reaches its true owner and take reasonable care of those goods, etc. And in this particular situation, what Rohan did was Rohan gave the wallet to the manager. Now, after a week, Rohan again inquires about it and demands the wallet back. So, in this situation, the manager cannot deny giving the wallet back to Rohan. Rohan has the entire right to recover the wallet from the manager. So, in the situation of finder of goods, the finder of goods has a right on the good except from that of the true owner, but yes, manager, he will have to return the wallet back to Rohan. The finder of goods has a good title to the goods which he has found, but not a better title than the true owner of the goods. So yes, in this particular situation, Rohan can recover the wallet from the manager. Moving on. Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26th of February 2021. So here there's one loan which has been provided on 26th of February 21. Let's just write it down so that we have the data with us. So it is 26th Feb 21. The amount is 80,000 rupees. The borrower, Mr. Mukesh, asked for a further loan of $150,000. So there was another loan of 150,000 rupees which was given. Mr. Sohan agreed but provided the loan in parts on different dates. However, this loan was provided in parts and on different dates. That is 1 lakh on 28th of Feb. And remaining 50,000 on 3rd of March. On 10th of March, Mr. Mukesh, while paying off part 75,000 to Sohan, insisted that the lender should adjust this 50,000 towards loan taken on 3rd March and the balance against loan on 26th of February. So here, when making the payment, Mr. Mukesh specifies that I'm paying you 75,000 and this 75,000 has to be adjusted against this 50,000 and the remaining has to be adjusted against the 80,000 amount. That is 50,000 here and remaining 25,000 here. Mr. Sohan objected to this arrangement and asked the borrower to adjust in order of date of borrowal of funds. However, the creditor does not want to do so. Let's see what the question asks. Whether the contention of Mr. Mukesh is correct or otherwise as per the provisions of Contract Act. So yes, contention of Mr. Mukesh is correct. So there are sections wherein we have understood about appropriation of payments. So therein we have understood that the first method of appropriation is when the debtor is making the payment, he himself specifies that against which debt he is making the payment, and the adjustment has to be done accordingly. If the debtor does not specify anything, then the creditor can adjust the debt in any manner which he wants to, in any form, in any order which he wants to. And the third situation is wherein both the debtor and the creditor do not do anything, then it has to be in the order of time. So here, yes, Mr. Mukesh's contention is correct. Second part asks us what would be the answer in case borrower does not insist on such order. Then in that situation, the creditor, that is Mr. Sohan, will himself decide as to how the repayment has to be, how the payment which he has received has to be adjusted. What would be the mode of adjustment or appropriation of such part payment in case neither Sohan or Mr. Mukesh insist any order of adjustment on their part? So in that situation, it will be adjusted proportionately. So in that situation, the payment will be adjusted proportionately. Moving on, state with reasons whether the following agreements are valid or void. The first one here is where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one of those courts alone and not in the other. So here, there are two courts which have jurisdiction to try a suit. However, the parties enter into an agreement stating that only they'll file the case only in one court. So here, there is no agreement and restraint of legal proceedings as such. So this agreement is a valid one. Next one is X offers to sell his Maruti car to Y. Y believes that X has only Wagoner car but agrees to buy it. So here, this is obviously void because there is no consensus addendum here. X, a physician and surgeon, employs Y as an assistant on a salary of 75,000 per month for 2 years. Y agrees not to practice as a surgeon and physician during these 2 years. So yes, this is a valid contract. Why is that? So this is an exception to agreement and restraint of trade. So restrictions in case of service agreements for a reasonable time span is allowed and it is valid. The next question here is, Mr. Seth, an industrialist, has been fighting a long-drawn litigation with Mr. Raman. To support his legal campaign, Mr. Seth enlists the services of Mr. X, a legal expert, stating that an amount of 5 lakh rupees will be paid if Mr. X does not take up the case of Mr. Raman. Mr. X, at the end of the litigation, Mr. Seth refused to pay the provisions of the Contract Act. So what do you think in a situation like this, will Mr. X be able to recover the amount? So this is again agreement in restraint of trade. So wherein an agreement in restraint of wherein an agreement is being made wherein a person is being restricted from exercising his lawful profession, then in this particular situation the agreement is void itself. So Mr. Seth cannot stop Mr. X from taking anyone else's case. So here in this particular situation, the agreement itself is a void agreement. So X, he cannot recover any amount from Mr. Seth here in this particular situation. So even though Mr. X has listened to what Mr. Seth has told, but Mr. X cannot recover any amount from Mr. Seth. The next question is, what are the consequences of destruction of specific goods before making a contract and after the agreement to sell is made? So here section 7 and section 8 of the Sale of Goods Act is being talked about. So wherein the goods perish before making the contract, then the contract becomes void ab initio. However, wherein the goods perish before sale, but after the agreement to sale is being made and before the risk passes to the buyer, then the contract can be avoided in certain situations. So this was a direct question. There's another direct question which says, what are the implied conditions in a contract of sale by sample under the Sale of Goods Act 1930? Also state the implied warranty. So here there's an implied condition, sale by sample, which is being specifically asked about here. What are the implied conditions here in case of sale by sample? One is the bulk should correspond. Buyer should have a reasonable opportunity to compare the bulk with the sample. And the third is the goods which are being delivered should be free from any defect and should be of merchantable quality. So these are the implied conditions under sale by sample. Talking about implied warranties, so there are 4 implied warranties: warranty as to undisturbed possession, warranty as to non-existence of encumbrance, then there's quality in fitness and disclosure of dangerous nature of goods. So these are the implied warranties. Moving on, Shubhangi went to a jewelry shop and asked the salesgirl to show her diamond necklace with sapphire stones. The jeweler told her that we have lots of designs of diamond necklaces but with blue stones, not with sapphire. If she chooses to buy herself any special design of diamond with blue stones, they'll replace the blue ones with sapphire stones. But for the sapphire stones, they'll charge something extra. Shubhangi selected a beautiful designer necklace and paid for it. She also paid the extra cost for sapphire stones. The jeweler requested her to come back a week later to take the delivery of that necklace. When she came after a week to take delivery, she noticed that due to sapphire stones, the design has been completely disturbed. Now she wants to terminate the contract and asks the manager to give her money back, but he denies. Now state with reasons where from the jeweler. So here it is an agreement to sell which has been made. Now, though the payment was made by Shubhangi, the property in the goods has not been transferred to Shubhangi yet. Fulfillment of condition, which is that the goods which are being delivered, they should be as per the promise which was made, as per the description which was given. However, here the necklace do not match the original design at all. So in this particular situation, yes, Shubhangi has the right to avoid the agreement to sell which has been made. And what would be your answer if jeweler says that he can change the design but he will charge extra cost? So here there's no question of paying something extra. The jeweler is only bringing the necklace back to its original position. He's only repairing it, so he cannot charge anything extra from Shubhangi. State the various essential elements. So when you're talking about sale of unascertain goods, in that particular situation, the goods should correspond with description and quality. They should be in a deliverable state, should be appropriated with the consent of either the seller or the buyer. They may either be assent can be express or implied. So these are a few essential elements involved in the sale of unascertain goods. Moving on, Mrs. Kanchan went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. Shopkeeper quoted the price of 125 per kg, to which she insisted she would like to see a sample. Now, shopkeeper, before she purchases, shopkeeper shows her the sample, and the sample exactly corresponds to the entire lot. So the sample matches the bulk. Mrs. Kanchan examined the sample casually without noticing that there was something mix of long and short grains in that basmati rice. The cook, on opening the bags, complained that dish, if prepared with the rice, would not taste the same as the quality of rice was not as per the requirements. Now, Mrs. Kanchan, she wants to file a suit for fraud, saying against the seller, stating that this is a mix of goods and he's selling goods of cheap quality. Decide the fate of the case and options open to Mrs. Kanchan for grievance redressal. Now, in this particular situation, what do you think? Is Mrs. Kanchan not at fault? Yes, she is. It is a sale by sample which is happening. Bulk corresponds with the sample in quality, and the buyer was also given a reasonable opportunity of checking and comparing the bulk and sample. However, Mrs. Kanchan, she was not careful. So here Mrs. Kanchan will not be successful because she casually examined the rice. So Mrs. Kanchan here does not have any option of grievance redressal. However, would your answer be different if Mrs. Kanchan specified her exact requirement of length? So in that situation, yes, that is sale by description. And if sale by description is happening, then the goods should correspond with the description. So in the second situation, yes, Mrs. Kanchan will have the right, and the seller will be held liable. Moving on. Ravi sold 500 bags of wheat to Tushar, each bag containing 50 kgs of wheat. Ravi sent 450 bags by road transport. Tushar himself took remaining 50 bags. Before Tushar receives delivery of 450 bags sent by road, he becomes bankrupt. Ravi, being still unpaid, stops the bags in transit. The official receiver on Tushar's insolvency claims the bags. Decide with reference to the provisions of Sale of Goods Act. So here can the official receiver claim the bag? Now we all know that the right of stoppage in transit can be used when a person becomes bankrupt and the goods are still in transit. Now Tushar has become insolvent and the 450 bags are still in transit. So Ravi here, the seller, has the right to stop the goods in transit by giving a notice to Tushar, and the official receiver of Tushar, he cannot claim those bags in case of Tushar's insolvency. That claim is not possible in this particular situation. Moving on. So what do you mean by partnership for a fixed period? It is a partnership which is designed for or has been started for a fixed period. When the continuing guarantee can be revoked under the Indian Partnership Act. So a continuing guarantee which is given to a firm or to a third party with respect to transactions, it will be revoked from the date of any change or a change in the constitution of the firm. So whenever there's a change in the constitution of the firm, the continuing guarantee will be revoked. And the next one is, what is goodwill? So there's no definition of goodwill, but in simple terms, it is the reputation of the business. So it was a direct question again. Moving on, Messrs. ABC Associates has been a partnership firm since 1990. Mr. A, B, and C were partners in the firm since beginning. Mr. A, being a very senior partner, aged 78 years, transfers his share in the firm to his son, Mr. Vikas. Mr. B and Mr. C were not interested that Mr. Vikas joined them as a partner. After some time, Mr. Vikas felt books were not displaying only a small amount of profit despite huge turnover. He wanted to inspect the goods. Here what has happened, there's transfer of interest, transfer of share by one partner to some other person. Now this person to whom the interest has been transferred, he wants to inspect the books of account of the firm as a transferee. So that is not allowed. However, other partners believed he cannot challenge the books. So can Mr. Vikas be introduced as partner if his father wants to retire? First one is, the answer to this particular question is, a person, he can be introduced only with consent of all the existing partners. But here in the situation, Mr. Vikas can become the partner only if Mr. B and Mr. C agrees to it. The second part here asks, as an advisor, help them resolve the issues applying to the necessary provisions. So, talking about the rights of Mr. Vikas, being a transferee, he only has a right to share the profits. He cannot inspect the books of account of the firm. He does not have the right to inspect the books of account of the firm. Moving on. With reference to the provisions of Partnership Act, what are the effects of insolvency of a partner? So insolvency of a partner will lead to his discontinuation as a partner. He'll cease to be a partner from the date when he's adjudicated as insolvent, and he'll not be liable for any acts of the firm which is done after he is declared insolvent, and the firm will also not be liable for any of his acts after his insolvent. So that is the result of insolvency of partner. Moving on. Master X was introduced to the benefits of partnership of Messrs. ABC and Company. So he's a minor or not a partner of the firm. Later on, Mr. a supplier of material to Messrs. ABC and Company. First, Messrs. recovery of the debt due. To what extent X be liable to Mr. L, who is the third party? Talking about the next point, can Mr. L recover his debt from X? So since X has not given any public notice that he has decided not to become a partner, Mr. L can recover his debt from X as well. Moving on. State whether the following are partnership under the Indian Partnership Act 1932. Two firms each having 12 partners combined by an agreement into one firm. So yes, this can be a partnership. It is two firms coming together. A and B co-owners. Co-ownership will not result into a partnership. However, here co-owners are running a business for profit. So in this particular situation, it will become a partnership. Moving on, some individuals form an association to which each individuals contribute 500 annually. The objective is to produce clothes and distribute the clothes free to war widows. So again, this is some social charitable cause. This will not result into a partnership. A and B co-owners share a rent of piece of land, so this is not a partnership. A and B buy commodity X and agree to sell commodity with share of profits equally, so yes, this can result into a partnership. The next one is discuss the conditions under which LLP will be liable and not liable for the acts of partner. So what are the situations where the LLP will be liable? So LLP is liable if a partner is liable to the person or any wrongful act or any omission which has been done in the course of business of the LLP and within the partner's authority. However, LLP will not be liable if the partner has no authority and he has done certain act. In that situation, LLP will not be liable. Moving on, BC Private Limited and its subsidiary KL Private Limited. So there's one company, BC Private Limited. It has its subsidiary KL Private Limited. They are holding 90,000 and 70,000 shares of PQ Private Limited. The paid up share capital of PQ Private Limited is 30 lakhs, that is 3 lakh equity shares of rupees 10 each fully paid. Analyze with reference to provisions of Companies Act whether PQ Private Limited is a subsidiary of BC Private Limited. So we have to analyze whether PQ is a subsidiary of BC. Now here in this situation, when we talk about a subsidiary company, there are two cases wherein a company may become a subsidiary. One is where the holding company controls the composition of board of directors. The other is where a company exercises control over more than one half of the total voting power, either on its own or along with one or more of its subsidiary. So here BC is the holding company and KL is the subsidiary company, and they together hold 1,60,000 shares of PQ Private Limited, which is more than half. The total number of shares is 3 lakh, and these two companies jointly hold 1,60,000 shares, which is more than half, which means that yes, PQ Private Limited will become the subsidiary of BC Private Limited as well. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited in PQ Private Limited? Now, what if KL Private Limited was holding the entire 1,60,000 shares and there was no holding of 90,000 by BC? Even in that situation, BC Private Limited would become the holding company due to the chain system, or it could be because a subsidiary of subsidiary is also a subsidiary company. Moving on to the last question. Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital 10 crore in the form of 10 lakh shares of 100 each. Narendra Motors Limited is holding 5 lakh 5,000 shares in Shah Auto Private Limited. Now, Shah Auto Private Limited also wants to claim the status of a government company, whether it will be called a government company or not. So, a government company is a company wherein not less than 51% of the total share capital is either held by the central government or state government, or partly by central government or state government. And a subsidiary of a government company will also get the status of a government company. Now, here in the situation, Shah Auto Private Limited will become a subsidiary of Narendra Motors Limited. Shah Auto Private Limited has 10 lakh shares in all, of which Narendra Motors Limited holds 5 lakh 5,000 shares, which is more than 50% total voting power. So in this situation, Shah Auto Private Limited will become the subsidiary of Narendra Motors Limited. And because of this particular situation, it becomes subsidiary of a government company. So a subsidiary of government company is also termed as a government company. So here in this particular situation, Shah Auto Private Limited, being the subsidiary of a government company, that is Narendra Motors Limited, will also get the status of a government company. So this was the last question. Now talk. So with this, we have completed the discussion of revision test paper for December 2023. All the questions here were a mixture of past examination questions and questions from mock test papers and previous revision test papers. And there were a few tricky questions, but if your concepts are clear, do not worry, everything is easy. So all the very best for your exam and stay connected. For any queries, you can contact us on forums, reach out to us on forums, and we'll be happy to help. Thank you.